Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content. And today will be the day I earn that subscription. For today's content, we will be joined by our good friend Rob from Law and Lumber to talk about some of the appellate options that, as we can currently see them, that appear to be facing our friends from the Johnny Depp case. Of course, these appellate options aren't not necessarily great in any sense of the word. At least for one side in particular. Amber Heard's side, not particularly great. But, we can dream. We can dream of ideas. And some people say, well, you shouldn't give Amber Heard ideas. Yeah, she could use all the ideas she can get right about now because things are not looking very promising for her. Johnny Depp, of course, has more promising ideas. So we're going to cover some of that today and go through some of that, talk a little bit about the appellate process, talk a little bit about what they're facing, talk a little bit about the time frame, which basically is going to be forever. So I hope you guys weren't waiting for a resolution from tomorrow, maybe a year from tomorrow, if you're lucky. Could be a little while. So all those things. And I want to thank you, the 884 of you who are currently watching this content, 963 of you currently watching this content, in fact, to let us go over some of these appellate possibilities. How fun and exciting. And we're just waiting to be joined by our good friend from Law and Lumber, Rob, who I'm sure is having a brief break, little drink, a little happiness, no problem. So we are going to try to go over that. So where are we in the process? Well, as Rob was just covering, we are currently in a motion to reconsider, which is kind of a formality at this point, to be quite honest. It's more about preserving the issues on appeal than anything else, and clarifying and helping to augment those issues on appeal is basically what it's for. So in a case, you need to preserve all the issues on appeal. If you don't use it, you lose it. And so the trial becomes an exercise of making sure to note those appeals and also keeping those appeals alive, because you can abandon those appeals through any sense of process. So I'll just make it really easy for you. For example, let's suppose something happened. Let's suppose there's just a truly objectionable question and the attorney does not object. Now, there might be a lot of reasons the attorney did not object. Maybe the attorney missed it. Maybe the attorney just thought it wasn't worth it in the end. Maybe the attorney thought that, it was really bad, but by objecting, they'd bring more attention to it. So there were counter considerations, right? So there's some gamemanship in here. It's like, first of all, I have to notice. And second of all, I have to decide it's a good idea. It's not a good idea because I've objected too much. It'll irritate the jury. It's not a good idea because it will break the flow and bring undue attention to it. It's not a good idea because I might lose this. And if so, they get to re-emphasize the same thing and I wind up worse position than I did. It's not a good idea because I'm flooding the jury with too much things, and I want them to focus on only really good things and not let them have so much stuff that they get lost in the noise, right? So there's a lot of reasons an attorney might not object. But if you choose not to object for any or all of those reasons, you're stuck with that decision. You're stuck with that decision basically for all of time. You can't go to the Court of Appeals and be like, hey, that question shouldn't have been allowed, because the Court of Appeals is going to be like, yeah, no. Probably should have told the trial court about that because they didn't have the opportunity to fix the problem. And we are not going to fix a problem that you didn't give them the attention to, right? We are here to solve their screw-ups, not your screw-ups. We are here to make sure that they got it right, not that you got it right. That's on you. So if this is a you problem, don't come to us complaining about it, for sure. Does Law and Lumber not have a link to this? He might not. Did I forget to actually give him the link to that? That'd be hilarious. I might have sent him, now that I think about it, I might have sent him the YouTube thing for the redirect, but might not have given him the link for him to actually be able to join. That would probably help. That would probably help if I gave him the link so that he could join the chat. Yeah. But here, this is a good example of the Court of Appeals is not here to fix your screw-ups. They're here to fix this court screw-up. So if you forget, for example, to send your co-counsel a link to the Zoom meeting, the Court of Appeals probably isn't going to care. So a little meta there. I did it on purpose for the meta. That's it. That's what I did. I did it on purpose for the meta, and you can't prove otherwise. Joining us here for the meta is none other than our good friend Law and Lumber. How are you doing, sir?
Doing well, doing well. I see that you corrected an issue that came in during trial. Was that a motion to reconsider?
Yes, absolutely. Yes. See, that's go. You know, someone brought something to my attention, and I did my best to correct the mistake. All kinds of meta. We're having all kinds of fun with it today, and I am so glad that you were here, sir.
You as well, buddy. Love it.
I think this seal as my background might be a little bit much. Maybe just go with, well, I could go with dragon. That'd be kick-ass. Or just nice black one maybe is the way to go for now.
Yeah, perhaps.
All right. So we were just discussing the concept of you use it or you lose it. Attorney fails to bring an appeal fails to mention the issue, you're kind of screwed. You got to bring it to the court's attention. All right. So you brought it to the court's attention. The next issue is did you fully preserve it? Did you make sure to tell them why, all the issues? Like, because the Court of Appeals isn't going to consider anything you didn't tell them about. So part of the motion to reconsider is to put on record all this stuff, not mostly for the trial court's benefit, but mostly for the Court of Appeals' benefit. Because, like, hey, this is totally what I was thinking of. And so you can use that as a basis to overturn the mean trial court, who also somehow in the split of a second was also supposed to notice this, which seems a little unfair in some respects. I guess that's why the burden is so high also for the trial court, because it's not just wrong, it's abuse of discretion. It's clearly erroneous. And this is probably why, right? Because we can't be that harsh on the court and getting it right in the moment either. So it's not just they made a mistake, it's they made a big mistake. It's not just it was a violation, it was a structural violation, it was a constitutional violation. It was a big deal. So it requires a little bit more.
Yep. And you heard, so the curious thing, you heard on Joe jumped in and said in New York, apparently, if you bring it in a motion to reconsider, that you might waive that issue on appeal. That's not the case in Virginia.
No, I never heard such a concept. This is very scary to me.
It scares the hell out of me.
But if that's true, why would you ever move to reconsider in the trial court? Like, ever? Because, like, I can't bring it up now because I got to preserve the issue for later.
Yeah. So you have one shot, like mid-trial, to get everything right in the heat of the moment.
On the fly?
That's intense.
And then you preserve the issue, and then you're expecting the Appellate Division in New York, not the Court of Appeals, that's somewhere else, the Appellate Division in New York to fix your problem.
Yeah, that's wild. Don't like it.
No, I don't like it either. Well, we'll just stick with Virginia for now.
Yeah.
All right. So this is part of the motion to reconsider is making sure all those issues are preserved, making sure that everything is noted. So the Court of Appeals has it all for the tee up. So what are kind of the issues they could consider in general? Do you want to just kind of go over the generalized, like, broad-based categories of things the Court of Appeals can kind of look at?
Yeah, let's do that.
Okay. So I think the broad-based categories that they can kind of go on to are, of course, objections. Every one of those is overruled or sustained, and there's a possibility they shouldn't have been. So those can be examined. Yeah. Other possibilities would be like witnesses that were allowed in or not, or the scope of those witnesses, especially as to experts. That can be a thing. Like, so it's possible for a court to exclude a witness. It's possible for them to only be allowed only in some aspect of their testimony. In experts in particular, that can get really interesting in terms of their scope or not. Although Virginia, at least this judge seems to allow scope, infinite scope apparently, which, okay, that's an option, I guess. All the scope. Let the jury sort it out. Isn't that why we came up with those things like Dahlberg to prevent that? But I digress.
I mean, yeah, as long as the judge is consistent, like that's my biggest gripe. As long as a judge is consistent in how they rule, I know what I'm facing, I know what I'm looking at. Like, it lets me plan.
Yes, very good. I'm now getting paid for jokes. I like this plan much better. I like the getting paid for jokes plan. Yeah. So I agree with you. As long as the judge is consistent, it's good, because you want to know what the rules of the game are. And as long as you know the rules of the game are, you can kind of make it work. And she's pretty consistent about her rules of the game. I have my criticisms to be sure when it comes to, for example, foundation and hearsay and how she views those things. But at least she's consistent for better or worse. So it's like, well, at least I understand the rules of the game.
Yeah, it's like an umpire in baseball, right? So an umpire, when they're calling balls and strikes, the Major League Baseball players, the batter doesn't really care when the call is, as long as the call is within, as long as that batter's box moves consistently, like you're not calling something wild out and then something wild in, you're kind of just in one little consistent box.
Yeah, and apparently one of the rules was the what if any magic words rule, which I think the judge hated her life a little bit for ever suggesting the possibility of such a rule.
Oh yeah. She should have shot back and said, "What if anything, Elaine, can you do to get your client to answer questions?"
That's the kind of thing I would do.
Yeah.
I'm not necessarily sure it's advisable, but it is the kind of thing I would do. Is the snark.
Yeah.
But this judge is all neutral and doesn't show her feelings or her disdain. What kind of judge is this? Man.
You saw some of that, like even at the end when she was like, "You guys are welcome back in my courtroom. Maybe not for a few weeks." Yeah. Or when she said to Ben Chu, "Well, you're always a little bit snarky or witty or whatever."
Absolutely, that was a nice little moment. Yeah, but I think I let my feelings show a little bit more often. I could definitely see myself being a little bit atypical, and maybe the judge asking questions and being like, "Okay, let's just cut through this bullshit. I'm going to answer some questions now. Try to save ourselves some time. Let's move on, people."
Yep, keep it going. Let's go. No, we got the point. She made the point. Go on, move on.
Yeah, let's move to the next thing. I'm getting tired. Exactly. So what we thought we'd do is we'd go over some of the issues on appeal. So at least what I've done is I went through and I highlighted portions of Ben Chu's motion to strike because I thought they would give me a good basis for talking about things. And in fact, noticed at least one tiny mistake, which shows that even the best can make a little bit errors. So, hey, there you go. Not that I've never made a mistake before in a filing. Like every 5 seconds. So I don't know how you want to go about doing this. Do you want to start, or do you want me to start, or what's?
Why don't you pull yours up? But on the topics that can be appealed, one that I think we need to visit specifically is pretrial rulings. So, for example, there was a demur and motion for summary judgments filed. Any one of those rulings that either allowed a count to stay in or dismissed a count, that's also something that you can appeal.
Yes, that's true. I don't know what that would be for Johnny Depp. Maybe for Amber Heard, everything that got kicked was for statute of limitations reasons, right?
In response, yes, hers were kicked for statute of limitations because the statements they were referring to were outside the scope of that. Then they pinned in on, that's why they were limited to Waldman's statements. But yeah, that's why all of her counts got kicked. But even her, when she filed that demur, and I'll pull that up, so I'll highlight some things in that.
Excellent. No, that's great. That's great. No, I love it. I love it. So I thought I'd go through a few things because I looked into the background. I pulled the cases that Chu was citing, and I thought that he highlighted a lot of these issues, and a lot of this sound good to me, and I was able to also agree with a lot of this. So it's a good basis at least to talk about. So this is from his memorandum to strike. So this is mid-trial. He's making this motion. You might have remembered him doing this orally at the end of, when did he do this? I guess he must have done this at the end of Amber Heard's case. And he is raising these issues. So I highlighted a couple of things that I thought were good in terms of the issues. So the agency issues for Waldman, the scope of the agency, are, I think, the best issues of the attack. Because obviously to some degree that must be true. Because the only thing that he was found liable for are Waldman's statements. And Waldman is the only way that Johnny Depp can be held responsible for Waldman is if Waldman is in some sense his agent. Otherwise, just sue Waldman, which, whatever. I guess you'd have to sue him in the UK since this is where the statements were made. But if you want to sue Johnny Depp for him, it can only be because Waldman is Johnny Depp's agent and he's acting on his behalf. So obviously, in some sense, that necessarily becomes the best basis to attack the things. So let's pull this up and I'll go through it to some degree. All right, so we start with kind of sort of obvious stuff and we go from there. Depp did not make the 3 statements at issue. He didn't himself make them. Obviously. So therefore, in order for Johnny Depp to be held liable for the conduct of this other guy, who happens to be his attorney, but in order for him to be responsible for the conduct of the other guy, there must be some showing that Johnny Depp himself participated, directed, or authorized him to make the statements, which would make him the agent. right? That's the nature of the agency. I am using you to do work on my behalf. I am employing you, directing you, putting you on place to do things for me. And incidentally, this is an interesting thing because this has been a bit of an issue, a little bit in some internet related lawsuits to some degree, where I've commented on this issue before, where you'll see someone in a dispute say things on a Twitter like, I want basically, go forth and leave a review, go forth and let your words be, your thoughts be known. And it's like, oh, great. You just deputized all of Twitter as your agent potentially. You just gave direction to 1 million people potentially, to go act on my behalf and, let your thoughts be known to blah, 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 and so forth. And so that can become a real problem. And I've at least seen cases that are touching on those issues. So there's that idea. So we start with the principle that there is no evidence of any communication or coordination between Depp and Waldman. We never heard anything about that at trial. We never heard anything that Depp told Waldman to go do stuff, specifically with regards to these statements. I mean, Waldman, of course, was saying it's conducted by privilege, which it is because he's an attorney. But you can't then assume, because you just don't have evidence. Mm-hmm. And then there's this footnote here that points out this also means that you can't prove the scope of it. So this gets into this idea. One of the grounds of appeal I see is the idea that he's not acting as an agent at all, which we'll get into a little bit more in the further discussion. But even if he is acting as an agent at all, you can't define the scope of the agency because it's all privileged. If it was just a PR guy, if it was just like basically anyone else, pretty much, you don't have privilege. So you can't basically say, well, I'm not going to answer that. But you can if you're an attorney-client. You say, well, I can't answer that because it's protected by attorney-client. You can't prove, I'm by necessity, you can't prove what I said to the client or what the client said to me. That's kind of the entire point. Those are protected communications. And you can't use my invocation of that protection against me because that would defeat the point. If we're in a normal kind of relationship, if it's just you and me, for example, and somehow I get responsible for something you say, and we're like, well, I'm going to comment in on it, you might get an inverse instruction. You might even get so far from the judge of saying possibly that you can use their refusal to answer as an indication of the worst possible scenario. You can use it to say that, oh, it must be as bad as you can dream because otherwise, why would they keep silent? It's called an adverse inference. An adverse inference. You can get that. But here you can't get that because the nature of it is protected by law. It's privileged. So you can't get an adverse inference because it doesn't make any sense.
Yeah.
Because otherwise it wouldn't be protected.
And I love that you chose this issue. This was my favorite appellate issue on Johnny's side. I thought this one was the one that the Court of Appeals, look, when you're appealing something to the Court of Appeals, there's the stuff that Kurt was talking about with objections and things that are made during trial, evidence being allowed in. Those are really hard to win on appeal. Mm-hmm. But you get something like this that has a lot of meat on the bones as far as law is concerned. And this is something Court of Appeals can take a look at, and really get into.
Yeah, so this is more on the pure law spectrum kind of thing, which is more for the Court of Appeals and more where my mind goes because I tend to focus on those issues. It's like, oh, he can't be an agent at all. Okay, that's just an issue of law. Can he or can he be? I mean, just can he or can he be? That's just a straight up issue of law. I mean, there's no facts to that at all. It's like, is it possible? Before we even get to facts, okay. How about the scope of it? Oh, we can't get to that. So how's the jury getting to it? I mean, that's just there's nothing here for a jury to latch onto. It's just a straight issue of law. It's more in the appellate domain rather than these borderline calls of like, okay, maybe it's this, maybe it's that. It's like, this is more black and white thinking, which appeals more to my sensibilities. So yeah. So, okay. So in the absence of this direct liability, which we've been talking about, then it's vicariously. So this is A therefore B, therefore C, A therefore C is vicarious, right? Yep. I know you, you know Ian, therefore I know Ian. Kind of idea. It's transitive flow. And so the idea is, well, he's my agent. In the absence of direction, in the absence of me saying things, the only other way I can get there is through this vicarious thing. It's because, well, basically I absorb that responsibility because he's acting on my behalf in lieu of some direction. Okay, so let's give that a shot. And then they note down here, okay, that Heard has the burden to prove clear and convincing evidence of malice by Waldman, not Depp. Correct. Because if you showed direction of Depp, if you showed Depp directed it, great. Then everything Depp knows gets imputed down to Waldman. Because if Depp directs Waldman, whether Depp tells him or not, Depp's in control of telling him or not. So if Depp knows, if he communicates it, Waldman knows. If he doesn't communicate, it was your decision, Waldman didn't know. Either way, you're screwed. Right? You were in control of it. So whether he knew or not, it's on you. But you can't do it the other way around with this thing. It's like, oh, Waldman knows, therefore you know. No, that doesn't work. It doesn't work the other way around.
That was weird to me from the outset. Like attorneys are a different, and you did research on this,
right?
On the issue of an attorney as an agent,
right?
Attorneys, generally speaking, are not agents for liability purposes because an attorney is a different type of animal. It's a different character. So I'm really curious to see what you found on that.
Correct. Yeah. So so you have to show it by Waldman. Because if you showed it by Depp directly, if you showed Depp directed it, then great, you can impute it down. But you can't do it because it's all covered by privilege. So you can't do that. So you have to go the other way around. But you can't impute knowledge up. So you have to show it by Waldman himself. And then he even notes that you can't say that principal's knowledge is imputed to the agent. Because no, Waldman must have made the statements knowing they're false with reckless disregard. You can't go the other way around. And then, of course, there is really no statements that he knew it's false. Okay, so now we're just going at the Waldman. Does Waldman know it's false or recklessly disregard? Well, can Waldman know it's false? Of course not. The only way that you can know it's false is basically by being there. Or by, it's the only, but Depp tells you it's false, but you can't get to that because it's all privileged. So you can't get to that. So the only way you can show that is by him being there. He's not there. So he can't know. Amber Heard can know she was there. Waldman wasn't there. He can't know. So it's just basically a total non-starter for his actual knowledge. And you can just kind of skip the rest at that point. Then you can go into whether or not he recklessly disregards. And they point out here, Waldman testified at length about 29 witnesses that he relied on. So this is, again, where it's like slightly less pure legally. But I'm like, okay, look, he has to recklessly disregard. He might have pled basically privilege to anything dealing with Johnny Depp versus in between Johnny Depp and him. But as to him himself, he testified about 29 different witnesses he relied on, informing his opinions. So, like, even if he was wrong, is he recklessly disregarding? So even if you can find fault in his statements, which, sure, why not? Let's just go there. He's recklessly disregarding, and this is where I go to the Court of Appeals and be like, I don't think so, Tim. I don't think that as a matter of law, this is sustainable. I don't think he could. I mean, what's the jury thinking? Are they saying they didn't believe him, that any of this happened? I mean, is it a question of credibility? I mean, it's a slightly weaker argument, but it's still a ground of appeal. I feel good going to the Court of Appeals with, like, how can he be recklessly disregarding in light of this? I mean, there's no one saying he didn't consult 29 different things.
Yeah, and the funny thing here is it's so, to be clear to the chat, these are two different questions. So the first question is, Adam Waldman is Johnny Depp. You have to assume that before you can even get to that second question, did Waldman know or not know? But even in that assumption and making that assumption, you have to make an additional assumption that basically Waldman shares the same brain as Johnny Depp in order to get past this thing, because Mr. Waldman, he's got these 29 witnesses. He's got a foundation for the statements he's making. The only way he doesn't have that foundation is if he and Johnny Depp share the same brain. So not only is Waldman now Johnny Depp's mouthpiece, but now Waldman is charged or is imputed with all of Johnny Depp's own knowledge, which just that's just bonkers to me, that an attorney could be charged with that, knowing everything my client knows.
And it doesn't even make sense for a lot, and because it's all privileged, you can't get to that anyway.
No.
And so it's like the whole thing just kind of collapses in on its own logic. Okay, and then they say, yeah, no jury could find Wallace acted with actual malice. That's just a legal determination, right? As a matter of law, they can't possibly find this. There's just no way. He was not present, so he can't actually know. I mean, that seems uncontested, just uncontested. He did extensive investigation, so how can he be reckless? So, great. Then we get into whether or not he can be an agent at all, and this is where I found a typo, incidentally. It says a person who hired an independent contractor is not liable for the independent contractor's actions, and then it cites this Sanchez's versus Medicorp Health Systems, 270 Virginia 299 344. That's supposed to be 304. 344 is the correct page number, but to a different reporter.
Yeah. So to Depp's team, if you want to piss off the Court of Appeals, you have them searching in a case, because when they cite these cases, we put an appendix on our briefs. The appendix has all of the cases that are cited, and if you tell an appellate judge this is the case, that second number there after the 299, that's supposed to be the page number where you're supposed to find the specific statement. If that's not accurate, you've pissed off the appellate judge, because now he has to go and search through, he or she has to go and search through and find what you were actually talking about.
Yeah. So that was a mistake, because I had to hunt for it. So yeah, that's how I know. Right? That's how I know that was a mistake. It's like, oh no, it's supposed to be 304. An independent contractor is a person who's engaged to produce a specific result, but is not in control of the employer. And I also looked up, by the way, this actual citation, an actual language of it, and it is a correct citation. The exact quote from the case is, quote, in Virginia, the doctrine of respondeat superior imposes tort liability on an employer for the negligent act of its employees, that is its servants, but not for negligent acts of an independent contractor. So yeah, basically, if this is an independent contractor, basically we're done. Seems to be what the Virginia Supreme Court said. So there's that. And then they note here that an outside lawyer is an independent contractor. Now here they do cite from a federal district case that even notes in this example that a law firm attorney working with a client is still an independent contractor. Even in that example, it's federal court, but it's not inconsistent with what the Virginia Supreme Court said. So works for me. I'm citing that. And then they cite here that a lawyer hired for the purpose of representing Mr. Depp is in fact an independent contractor. And they cite some relevant authority for that proposition too from the California Court of Appeals, which again, it's better than nothing. So I'll take it. And of course, they say that he's not in fact an employee of Mr. Depp, which seems just uncontestable as well. And therefore, because he's an independent contractor, we're just done. So he can't, so this entire thing falls apart on like 3 or 4 different levels of the analysis. So those were the issues I highlighted in prep for our little discussion.
I love it. So that gets, so if that's the issue on appeal, let's say that's the issue on appeal.
Mm-hmm.
How does the appellate court take it up? How do they look at it?
So I guess the first, well, I mean, I would take it up in the issue of, can he be an agent at all? Because that's the easiest. It's like, what, because I can choose these issues in any order. So I'll choose the threshold issues, because if I can dispose of it on a threshold issue, then I don't have to answer any more questions and I can go home earlier. And I like that plan. So the easiest way for me to solve this as the appellate court is just for me to say, well, he can't be an agent. So I don't have to worry about scope of the agency. I don't have to worry about the 29 witnesses. I don't have to worry about imputed knowledge. I don't have to worry about all that crap. If I can solve this on he can't be an agent, end of analysis, I get to go home. So that's where I start. It's like, well, can he be an independent? Can he be an agent? If it's true, as it seems to be the case from the Virginia Supreme Court, that independent contractors cannot be agents, great. All right. If that's true, fantastic. Now all I have to decide is if he's an independent contractor. And I'm basically all the way to yes before I even started. Because, independent duties to the court, they have independent responsibilities. I have some case law that kind of banters around this point. So I'm like, and even in this particular situation, he's not an employee. He's just a guy that's being retained a lot because he's really, really good. It's like Camille Vasquez just got hired by Johnny Depp again for that other case that they're fighting about. The guy punching him in the gut or whatever. I forget about the movie set, blah, blah, blah.
Oh, that one.
Yeah, so she just got formally retained for that case. I'm like, so is now Camille Vasquez suddenly Johnny Depp's employee? I thought she was a partner at a law firm. I'm so confused. Which one is it, right?
Oh, that's scary because now with the understanding that Camille Vasquez, anything she says right now, if it's a factual assertion that can be tied to Johnny Depp, yeah, that's interesting.
Yeah.
Yeah.
So I think as a matter of law, I'm very inclined to say that in the vast majority of situations, in fact, in pretty much every situation, I'm hard pressed to think of one that doesn't quite apply. Maybe in-house counsel, maybe, but even there's some case law seems to suggest against that. But short of that, you're not an employee, so I get to go home early.
Yeah,
I like the go home early plan.
and this is a really good. So Kurt's reached a conclusion, but this is a good place to kind of to back up a little bit. And what is the Court of Appeals of Virginia, and who's going to hear it, and how they're going to hear it? So Court of Appeals of Virginia just expanded to 16 judges. I think they were 11.
Have they appointed them all yet? Because I know the legislature doesn't normally meet at this time of year, but I'm available. If they want to hold some emergency session, appoint me. I'm willing to come back.
You want that massive $20,000 a year stipend they get for being there?
I'll take it. That'd be fun.
Yeah, not a bad bonus. No, but so they have the 16 judges filled, and they expanded that because they just kind of created an appeal of right in the Court of Appeals for civil matters. So this is an appeal of right. So they have the right to make these assertions. They file a notice of appeal within 30 days after that final judgment. Then a 3-judge panel gets assigned. So 3 of those judges gets assigned as a panel to hear over this dispute. Mm-hmm. And then they begin a briefing schedule. The person who files the appeal files an opening brief, which is 30 pages, I think, limited. Then the respondent gets to file a responsive brief, 30 pages. And then the appellant, the person who brought the appeal, gets one more crack at it to do a response to anything that was raised in that response appeal. That's a reply brief. Mm-hmm. After those 3 briefs are filed, the matter is considered to be fully briefed. The issues are prepped for the panel to hear. Mm-hmm. Then the judges say, are we going to allow oral argument or not? In Virginia, you have the right to waive oral argument and have the judges decide on the pleadings, or you can force oral argument, in which case you say, I want to argue to the 3 of you so that you can see what I'm saying, and I can try to persuade you then. Mm-hmm. Practice pointer for all practitioners in appellate law. Generally speaking, you're not going to change a judge's mind during oral argument.
No, it's very hard. It's same thing on a U.S. Supreme Court. I've often said, and I think it's true, that you can't win in an oral argument, but you can lose.
Yep. But you can score points on not points for the judge, but points for your client and points for the game of politics that you're playing. Yep. But that's really the only thing you can do in oral argument.
Well, I know. I think there's only one thing for it. You have a Virginia bar number. I have a Virginia number. I'm seeing in our future an amici brief and a motion for division of time. As an amici, I'm seeing us getting 7 minutes at the Court of Appeals in the oral argument, Rob.
Yeah, LawTube has a vested interest.
LawTube has a vested
intervene.
Yes, I love it, Rob. We have a vested interest. Let's write an amici.
Motion to intervene on behalf of Johnny Depp in the Walden.
It could even have jokes in it because I like jokes. So let's see if the Court of Appeals likes jokes.
Oh God, that'll be great. Oh my gosh. I'm just thinking about some of the judges that are up there. So those judges, generally speaking, are selected from the circuit courts in the Virginia. So there's a couple in there from Northern Virginia, and that would be interesting. I think they wouldn't appreciate me appearing. They probably would. It'd be funny.
We can do it on my bar number. I'll never see these people. That's fine.
So yeah. So the arguments that are made, oral arguments, and the briefing schedules, all of that stuff. So this stuff takes a tremendous amount of time. I mean, you're dealing with 60-day windows, 30-day windows, and with a case like this, I imagine. Actually, this is probably a good place to talk about it. There's 2 different approaches to appeals. One is what I call the shotgun approach. Kurt, I think you've called it the kitchen sink approach before.
Not a fan.
Yep, I hate it. You basically throw every issue that you can spot in a trial, and you throw that out there and you just throw it against the wall and see what sticks. The problem is that you don't get to make your briefs longer. So depending on how many issues you want to go with, you now have to fit those within 30 pages. Can you imagine in a 6-week trial? Oh my God.
I don't even really think that's the biggest problem, because I don't think the page count's the biggest problem, because even if I had more page count, I wouldn't want to do it anyway, because the problem is I dilute the good with
Yep.
the average and the bad is more my problem. It's like I've often commented, I've told people about this, like, assume I have 10 arguments, assume I have 10 appealable arguments. Do I appeal all 10? And the answer is, well, no, not necessarily. It's question of how good are they? Because if I have one really great argument and the others suck, I mean, there's as good a chance as any that the appeal court loses interest, that they see the sucky, they assume they are all sucky, because just human nature, right? They just kind of like, it's kind of the grouping of what's there. You know, if 9 out of 10 of them are bad, they're going to assume all 10 are bad. They're not going to take the time probably to notice. So I'm more of the school of bring the issues that are the best. And it's like I've got 3 or 4 or 5 issues for Johnny Depp that are workable in this agency, and they're all related to the same theme, which is all nice. So in some sense, I could argue they're all one big issue if I were so inclined.
Mhm.
So it's like, why not just go with that and just forget the rest? I'm not going to argue about, I'm not going to argue about the objections. I'm not going to argue about the demurrers. I'm not going to argue about things getting kicked out. I'm not going to argue about, so many other issues. It's like, I've got my ones. I'm happy. Let's go.
See, you don't like the demur argument. I do. I think that's one of Amber's strongest, to be honest.
Okay. I haven't looked into it that much. Maybe you're right.
I think the reason why is that, I mean, this is also a good time to talk about,
because you want to talk about Amber's appeals. I've been talking about Johnny Depp, so why don't you talk about it more?
Yeah, let's do that. So the thing we talk about is on the appellate level, there's different standards of review. So the appellate court is given the ability to take a look at what the trial court did, and they apply different standards based on the question being asked of them. If the appellate court is being asked to rule on a pure decision of law, for example, a demurrer. Actually, let me do this. Okay, I actually highlighted this. Share screen. Boom, boom. There it is. Pop it on up.
Sure.
Okay, so this is from the opinion for the demurrer case. And this was when Amber Heard filed a demurrer saying, please throw out Johnny Depp's counts because he has not properly alleged a claim for defamation. Virginia, as a lot of people have seen, adds or has a cause of action for defamation by implication. It's a stretch. It's something that the courts have routinely relied on, but it's also a purely legal question. Do we still recognize this as a cause of action? And when the court's ruling on a demurrer, they're ruling purely as a matter of law. So when you're looking at this part of the opinion, this is the question that the appellate court now gets to ask themselves in what it's called a de novo review, which means that they look at the legal issue brand new, as if it was never heard or argued before, because it's purely law. You don't have to hear any facts going to it. You don't have to do anything like that. It's just law, which is, I mean, that's Kurt's bread and butter, man. That's what I
like.
Oh, yeah. And the appellate court likes it too, because they don't have to get in the weeds. So as a pure matter of law, the court looks at the pleadings and they say whether the facts pleaded, implied and fairly justly inferred. So basically that says in the best light taken to this person's case. So we look at the pleadings themselves and say that we have to assume this is true. Well, are they legally sufficient to state a cause of action for defamation? And then the court looks at those 3 questions. The elements for defamation include publication, actionable statement, requisite intent. And then it says this is what the trial judge has to do, responsible for determining whether, as a matter of law, the defamatory statements are actionable. So they do this legal analysis here. And then the trial court issues a decision like that and says, this one is actionable. So what you have is the articulated standard, the law that the trial court has to apply. And then you have the finding the trial court reaches. Now the Court of Appeals gets the chance to do all of that analysis again. They can take a look at everything that was done and they can say, is this an actionable statement? Now, after a 6-week trial, you can imagine the Court of Appeals doesn't want to reopen this one, but they can if they felt so inclined. And if it's purely a legal issue, they feel like they would have a lot more strength in making that determination. So I thought that this was probably one of Amber's strongest, where go back to these statements and are these truly defamatory in nature? Can these be a legally cognizable claim against Johnny Depp?
I mean, as to 1 and 2, as to 3, I'm not so sure.
Yeah. So,
even 2 is a little bit more iffy, but I mean, I spoke up against sexual violence. As long as you conclude that some aspect of the article is about Johnny Depp, then you're there kind of on the end, right?
Yeah. And 3, let me see if I can pull up 3. Dun, dun, dun. The third one that you talked about was this one, right? I had the rare vantage point of seeing in real time how institutions protect men accused of abuse.
Yep.
And it's like, okay, does that one survive? So can Johnny Depp win? Can this even get to a jury? That's the question the Court of Appeals asks themselves.
I'm having a tough time with that one because I think it's literally true. And even it's about Johnny Depp, like what is the defamatory implication about that sentence about Johnny Depp? It's a little okay. I'm having a tough time with that one.
It's that last part of it, how institutions protect men accused of abuse, inferring and asking you to draw the inference that Johnny Depp is in that category of persons. That Johnny Depp is in the category of persons, men accused of abuse, and that.
But he is, though.
I know. So
it's a bullshit accusation, but still.
Yeah. So that's why I think that when you're looking at Amber Heard's case, look, the argument that there was an error at trial, for example, Amber Heard coming and saying, look, you excluded my medical records.
Mm-hmm.
The medical records, hypothetically speaking, and you heard Elaine Bredehoff say this, we had medical records. Well, the medical records were psychotherapist notes.
Right.
And what they wanted to introduce was Amber Heard telling her psychotherapist, I was abused. That's what they wanted to use and include. Well, that's just
hearsay.
Yeah. But to try and convince a court of appeals that type of error, which is an error that the judge
has. What I think about that.
Oh, yeah. I mean, the trial judge has absolute discretion in what evidence they allow in.
Well, no, it's quite that. It's not quite that broad, but it's close. It's like even if they're wrong, if they were wrong about the evidence should have come in, you still have to show abuse of discretion on top of that, and good effing luck.
Oh yeah.
So not only does the trial court have to be legally wrong, that it really wasn't a hearsay problem, which is a legal error. On top of that, they would have had to abuse their discretion by excluding it because even they're like, you know what, that's totally admissible, but no. Because the trial court can do that. Because to some degree, they are doing that by saying, well, okay, the trial's going to be 61 and a half hours long.
Yep.
It's like that's how much time it is. And
there's
you see that in Rittenhouse case as well, where it's like, we have these 20 witnesses who are all going to say the same. It's like, how about 3? How about the 3 witnesses who are going to say the same thing? It's like, where did I pick up the number? I don't know. I'm the judge. Tell it to the judge. Oh, wait, that's me. How about 3?
Yeah. And then there's the third part of that equation where they really get screwed, which is not only does those 2 things have to be wrong. So legal error, abuse of discretion, but also now you have to prove that evidence, if it had come in, would have changed the jury's mind.
Oh, yes. I forgot about that factor. Yes. Thank you. I forgot about that. Yes. Do we care element, which is also the fun one. It's like, yes, it has to have actually would have changed the verdict on top of that. So first of all, the judge has to be legally wrong. It was legally admissible. Second of all, it has to be abuse of discretion, not to admit. And third of all, it would have had to have mattered. So this is where I come. This is where you come to me if you're Elaine, or you come to me if you're Amber. I'm like, I want to appeal. And I'm like, no.
Pretty much. Yeah.
It's like I have money. It's like I'm gonna want it in like gold bullion up front. I'll tell you what, man. Shit, dude. Because it's like I'm not getting any money on the back end. I'll tell you that for damn sure.
Yep. Give me 2 seconds. Be right.
Okay. Well, Rob needs 2 seconds. That's fine. Rob can have his 2 seconds. We are having a lot of fun here on Uncivil Law. I hope you're having a lot of fun too with this insightful commentary. And I would just like to thank all 4,300 of you who are currently watching this channel. It is really, really appreciated as always. And I just want to remind everyone who might not be familiar with my channel that we do have a lot of great content on here. We recently covered some Supreme Court decisions. We're going to be covering more Supreme Court decisions. Of course, we're waiting for the big decisions, Dobbs, the abortion case that may or may not overturn Roe. We're looking forward to NYSRPA, the case dealing with concealed carry or open carry or carry without some kind of permit. Waiting on that. And there's a couple other ones. Like there's also a decision dealing with, I can't remember the name of the case off the top of my head, but there's a case dealing with Miranda and whether or not you can sue a cop for monetary damages for violating Miranda rights, which might, in some sense, potentially overturn Miranda. It seems unlikely, but there's justices of the Supreme Court who are not huge fans of Miranda. So it'd be interesting to see which way the case goes on a whole bunch of grounds on those reasons. So just want to remind you, there is a lot of great content. We try to release something every day, at least, or have a live every day or something else. We're going to, in the near future, also be doing a lot more about the Daybell trial, Daybell Vallow out of Idaho, this cult murder trial. That's ramping up. That's going to be in January. So we're ramping up coverage relating to that. And we are trying to also do just more coverage, Court of Appeal stuff. There's so much happening all the time. So just want to remind everyone about that. If you're not familiar with my channel, if you'd be so kind as to please click that subscribe button. If the subscribe button is red, it's red because it's angry. It is not the subscribe button it wants to be. But you can help change that by clicking that red subscribe button and help it become a gray, calm, content subscribe button. You can be the change we want to see in the world. Please hit the subscribe button today. Let me welcome back my guest, Rob from Law and Lumber.
I heard Supreme Court stuff, and I want to talk Supreme Court stuff.
I love Supreme Court stuff, man. We can talk Supreme Court stuff for sure.
Hit me with the Miranda case. What's that case? I didn't see that one.
Okay, so this is I don't remember the name of the case off the top of my head. I'd have to double check it, but there's a case dealing with a cop didn't give Miranda. And part of it was suing the cop, I believe it was 1983, for deprivation of rights for failure to read Miranda. So the evidence got suppressed, I believe, or maybe the case, I forget exactly how the evidentiary picture went in the case. In the case, I don't remember, maybe it got not convicted, maybe it got dismissed. So there was some criminal case, but that's aside now. So now we want to sue for the civil rights violation for the violation of not reading Miranda. So first of all, we have to decide, is Miranda a constitutional decision, which the answer seems to be yes. This was a bit of an open question until very recently. Like 2 or 3 years ago, I think this question finally got resolved that from the U.S. Supreme Court that Miranda was actually a constitutional as opposed to a prophylactic decision. So that seems to be the case. So if it is a constitutional decision, then one would think that would mean that it and it's well established, then we're thinking about 1983. So it's 42 USC 1983 when we want to sue a state law enforcement officer for violation of our rights. If we want to sue a federal officer, just go to hell. I just covered that case on my channel very recently from the U.S. Supreme Court, came down like yesterday. Basically, if you want to sue the federal officer, go to hell. If you want to sue the state officer, however, 42 USC 1983 is your go-to. You have to show that's a violation of your constitutional rights, which is pretty much a gimme. Then you have to show it's clearly established, which is basically borderline impossible, but maybe this is one of those exceptions. And part of that is sometimes you can get monetary damages. So that seems to be what's going on, and the court did award monetary damages. It's now at the U.S. Supreme Court to determine, I suppose, whether or not you can get monetary damages and or whether or not Miranda continues to exist.
Interesting. So there's going to be a lot of people really nervous about this one because the Supreme Court has been, so they opened the door a little bit on federal claims against federal officers with the Border Patrol agent. Remember that one a couple of years ago? Yeah. And it looked like there might be an avenue, but ever since that opinion, they've just narrowed it and narrowed it and narrowed it to where it almost doesn't exist.
Oh, no. Yeah, no, they hate it. No, they hate it.
If the Supreme Court has this in front of them, I mean, 1983 claims might just take a big hit. Who knows? Could do. Since they just killed Bivens again for like the 12th time, literally, which is the one that would allow you to sue federal officers, but no. I mean, Bivens right now has a bunch of bullets in it. Like that piece, if you held that opinion up, like you would see just Swiss cheese. I'm amazed at this point they just don't overturn Bivens. I'm not sure it was wrong in the first place. And I'm not, but even if it was, why not just take it out the pasture? Like, what are you waiting for? But the argument every time it comes up, the appellant always argues, just put it out to pasture. They always ask them to do it. They ask them to do it every time, but they won't do it. No. Just like Lemon versus Kurzweil with the religious thing. Because Lemon has been beaten to death, but they won't put that out to pasture either. No. And the funny thing is, if you cite Lemon right now in the appellate courts, you're good luck. Like you want to hitch your horse to that wagon. I'd cite Lemon just for the lulz because I'm that kind of guy. You would cite it and then immediately distinguish with the next 4 pages of your argument. That's fine. I can roll. No, this term has been really interesting. It's been pretty wild. Yeah.
Absolutely. Oh, apparently we hit 97,000 subscribers. Yay. Did I bing yet? Oh, I did bing. Hello. Excellent. I didn't actually hear it, but apparently my counter went off. Yay. Nice. So I hit 97,000 subscribers. Thank you very much
Awesome.
for everyone who's there. So that puts us only 3,000 subscribers away from that 100,000 mark, which I'm very excited about.
That's great.
Okay.
Man.
I know.
Well,
very, very exciting. So thank you very, very much for all the love, the hats and orange hearts. It is very, very appreciated. Okay, so yeah, there's those issues, and okay, and the Supreme Court has 18 cases left to decide this term, which is a lot.
that number is the craziest number that I have seen this late in the term. I've never seen them hold off on this many opinions and drop them in like the last 2-3 weeks.
Drop it like it's hot. Drop it like it's hot. Yeah,
dude, that's how bad are we as law nerds that you just said drop it like it's hot, and we both got excited about Supreme Court opinions.
The case I was talking about the Miranda thing is a case called Vega versus Tekoh. Tekoh. Damn. Tango, Echo, Kila, Omaha, and Hotel. Great. So those are all the cases. Okay. Then there's another case coming down, which is also interesting. Oklahoma versus Castro Herrera. Now, without me saying anything else, you should instantly know what the issue is, and you should instantly know what the issue is at stake is. It's Oklahoma versus, you got it, right? And so it's a question about potentially re-examining, limiting the decision that from Gorsuch like 2 years ago about half of Oklahoma not being in Oklahoma anymore.
Oh, wow. Okay. That's going to be funny. That's going to be another fractured opinion.
Yes, the question is technically whether a state has authority to prosecute non-Indians who commit crimes against Indians in Indian country.
I saw that. I listened to that argument. That was freaking wild.
That case from Gorsuch, though, when he wrote that, though, I thought he was exactly right, though.
His opinion was
brilliant. It's brilliant.
Well, and that was when I kind of fell in love with his writing. Like his writing in that opinion was just it was perfect.
The one that got me was the gays in the workplace decision. That's the one that sold me on Gorsuch.
I didn't see that one. What opinion was it?
Well, there was a twofer because there was two cases, or maybe it was three, as technically that got consolidated into two. It was a discrimination on the basis of sex, Title 7 of the Civil Rights Act, which prohibits discrimination on the basis of sex in employment. The question was, is discrimination on the basis of sexual orientation and or the discrimination on the basis of transgenderism prohibited by that law?
And was this the funeral home worker?
It was the funeral home worker was one of them, yes. The funeral home worker was the transgender one, as memory serves correctly. Yes.
Yep. And didn't Kavanaugh write something in that one?
Yes, he wrote an opinion saying the other way around from what might be considered a more traditional originalist perspective. And for me, at least, this is where I, at least in my own mind, split the concepts of originalism versus textualism and decided that these were now two different things. Because I thought Kavanaugh's decision was more originalist and Gorsuch's decision was more textualist. And I can walk you through it if you like.
Hey, it's your channel, man. I love this stuff.
Well, I don't want to talk down to you. So, I just thought
I love this stuff. Kavanaugh's frustrated me recently. His questions drive me freaking nuts. It's like he cherry picks from the easiest possible questions, and it's like, why are you asking this?
At least it's not just Spryer.
I mean, the kale stand. Like, let's say that I sell kale. Let's say that I sell kale out of a stand. I want to put a sign in front of my kale stand. I don't know.
Questions that go on forever and have no point. Anyways, I got distracted. I'm sorry. Okay, so the relevant statute prohibits discrimination on the basis of sex in employment. All right, that's what we need to do. All right, so Kavanaugh's decision basically is saying this in so many words. Look, when they wrote this thing in 1964, which I believe is the correct year, when they wrote this thing in 1964, first of all, they explicitly considered the concept of adding sexual orientation in 1964. And the Congress went, yeah, not so much, because in 1964, you don't get that passed. You have enough trouble in 2004 getting that passed. So first of all, they explicitly considered it and said no. So there's that. And second of all, when they thought about discrimination on the basis of sex, right, no one thought about this. So let's look at the text. Let's look at the original purpose. Let's look at the original meaning. Let's look at this original thing, blah, blah, blah. Therefore, they're not protected. So this is Kavanaugh and Alito on the one hand. Gorsuch writes this brilliant textual argument, and it just sells me. So Kavanaugh says, look, let's just look at what the words mean and what they meant at the time, right? We'll just do this straight textualism, original meaning. All right, it prohibits discrimination on the basis of sex. Those are the words Congress writes. Great. What does sex mean? Well, it means it's the same thing in 1964, at least that it did up until, I don't know, maybe 2016, if you get my drift. But at least until 2016, it meant men and women, right? when we believe in such concepts.
It was gender. It was you are male, you are female. It was biology.
When we believe in these concepts, right? So here's what he says. He says, okay, sexual orientation as such is not protected by the Civil Rights Act, but sex is. He says, but you can't discriminate on the basis of sexual orientation without discriminating on the basis of sex. And so he has a lot of great examples to prove this. And he says, okay, you have two employees who work for you. You have Joe and Susan. Both Joe and Susan are married to women. They're married to different women, but still, both Joe and Susan are married to women. You fire Susan. You say the reason you're doing it is sexual orientation. But actually, no, it's the reason is sex. Because they were both doing the exact same thing. They were both married to a woman. Joe's married to a woman. The only reason you fired Susan is because she's a woman. If Susan was a woman, you wouldn't have fired her because you didn't fire Joe. Right? You fired Susan because she's a woman. If she were a man, you wouldn't have fired her. So sexual orientation actually is irrelevant. Because you have both a man, Joe, and a woman, Susan. They're both married to women. They're both engaged in the same behavior. You fired the woman, not the man. Wow. Because she's gay, but she's only gay because she's a woman. So therefore, it's discrimination on the basis of sex. And I'm
so
like,
he basically,
this is great.
He took the argument that was, A plus B plus C equals D. And it was just if A, then D. And then he says, no, we're going to ask this in 4 different questions. A, B, C, D. And it was, you cannot get to D unless you have said sex.
Right. You can't say that they're gay unless you determine which sex they are. At which point you've determined which sex they are, at which point you're discriminating on the basis of sex. And I'm like, oh, you're absolutely right. So I don't have to change one word of meaning in the original law. Sex means exactly the same thing it always did. Discrimination on the sex means discrimination on it's a but-for cause. But for them being that sex, I want to fire them. Well, this is but for. I got 2 employees. They're exactly the same in every way, because it's my hypothetical. They're exactly the same in every way, including the fact they're both married to women, incidentally. I'm only firing the one, not the other. Well, what is it other than sex? And you're like, ugh. And you're just like, it doesn't work. So therefore, it must be discrimination on the basis of sex. So therefore, it's protected. Therefore, even though Congress didn't write sexual orientation, they wrote sex. And it's like, well, they didn't write. What they wrote is just covered by literal words. I'm like, I'm sold. And basically the same logic for transgenderism. It's like, well, you can't be transgender. It's like you have a man and a woman. You have a man who's now a woman. Well, why are you firing him? Well, because he's a man who's now a woman. But what if he was a woman the whole time? You wouldn't have fired him. So you're only firing because he's a man who's now a woman, which means you're discriminating on the basis of sex. And you're like, oh yeah, okay, that works logically. I can't fight it, and it makes me so happy inside when you make this great logical argument. And I'm like, oh, this is logically required. I can't believe anything else, and it just makes me so happy.
It's so much better, and I feel like it's on such better footing than any of these arguments that are the feelings. Like this is a fair thing, or this is fairness. It's like, no, you start just saying things are fair or unfair.
That's some bullshit Breyer would write about fairness, and I get all lost. That's like Obergefell, where we start talking about fairness and liberty, about gay marriage and liberty, and I just want to go off a cliff and die. Because we're just talking about these loose amorphous concepts. I'm like, there's easier ways to do this rationally. It's like I decide Obergefell basically for lack of a rational basis. Breyer's over here with this touchy-feely bullshit that I can't, deal with. But it was Kennedy. I apologize. Kennedy's over here with this touchy-feely bullshit on Obergefell. I'm like, there's ways to do this on pure logic that are much more attractive to me. So,
And to anyone who's watching right now, neither Kurt nor I are making actual judgments on the actual outcome of the case. What we're judging is the logic. How do you get there? It's how you get there. That is the foundation of our entire jurisprudential system. It is based
logic
on,
kicks ass.
Yes, you need it.
Logic kicks ass. So it's like, show me a logical argument. And that's what I like. It's like, hey, to forget all this touchy-feely bullshit. It's like, yeah, man, I have feelings. I'm like, no, I have words. Words kick ass.
Yeah, draw the line. Make the connection. A plus B equals C.
Yeah. So, yeah. Transgender is not sexual orientation. I don't know if maybe I got lost. I didn't mean to say that it was a sexual orientation. I just meant either way you're discriminating on the basis of sex, because you can't be transgender without being a different sex first. So I didn't mean to say, or if I did, and maybe it was a misspeak, I didn't mean to. And also, it's like, yeah, the only reason they're transgender is because they were the other sex first. But that's the exact problem. You're discriminating because they were the other sex first. No, and if if it's like a woman transitioning to a woman, it's like, well, that doesn't really make any sense, but okay. So they were always a woman the whole time versus a man transitioning to a woman. Well, the only difference between the woman transitioning to a woman and the man transitioning to a woman is that the man and the woman are different sexes, at which point it's discrimination on the basis of sex. And I'm like, oh, okay, well, yeah, there you go.
Yeah. Stop reading into anything that Kurt or I said. Stop reading into it. You're reading too far into it.
I get a little bit irritated when people read into it, because it's like I usually am making more precise points. Like when for example, when I say, oh, I hate Kennedy's decision in our Obergefell on the gay marriage, it's very easy to misread that as being me saying I disagree with gay marriage, which I'm not saying. I'm saying I don't like his opinion. And I even go into the point of saying, I think there's a way to write it in a way that doesn't run into these problems. I can do it on a pure rational basis argument and just pure logic, and I think it's better. So it's a basis for the way of thinking about it versus the outcome. So, yeah.
Yeah, it just makes for stronger precedent. When you have precedent that's founded on that type of logic, then it's harder to attack it down the road. Right. That's the thing. Like, people are asking about Roe. The problem with Roe is that it never had that foundation, not that logical. So people have attacked it ever since it was passed, or ever since it was decided.
Right. And Roe is very hard to justify from its own foundations, because it doesn't really make any sense. And when I read the leaked opinion from Dobbs, is like, well, I thought, at least as the aspects, I thought Alito was very good. And then trying to show that I'm trying to be reasonably objective, I thought Alito's analysis as to the whole quickening stuff left a little bit to be desired. I thought this part of the opinion's a little weak. But on the actual part of like attacking Roe, I'm like, yeah, it doesn't work. It's like, how are you trying to do this? It doesn't work logically. You'd be hard pressed to find a lot of people who will define Roe based on its own terms. They'll defend it on pragmatic grounds. You know, we don't want illegal abortions and women dying in the streets. They'll defend it on some sort of bodily autonomy grounds. Women should have control of their bodies. They'll defend it on jurisprudence, stare decisis, and things aside. But it's very hard to find people who actually defend Roe from its own first principles, because it just doesn't make any sense.
Yep. And this is speaking just legally sound, not whether it's socially, morally. I'm not making an opinion on any of that.
Right.
I'm saying, as a legal foundation, if you're building a house and you build the blocks, you have to build the blocks in order for the house to stand. And there's not a whole lot of meat to that decision.
Right. And I find, at least for myself, somewhat comforting to be able to think about that, because I had a conversation with a girl recently in a sort of dating environment, and she asked, so what's your, do you consider yourself conservative? I'm like, yes, I consider myself conservative. And it's like, oh, so you hate abortion? I'm like, well, first of all, that's a bit of a leap for its own terms, but I'm like, okay, I don't confront it. So it's like, and she starts talking morality to me. She starts talking the moral position on abortion. And so I just say to her, well, yeah, okay, but I just don't really think that way. I think more in terms of the legal aspects rather than the law. It's like, I don't really take a position on the morality of abortion. I just take a legal position. And then we just proceed to have a very frustrating conversation, because she kept talking morality and I kept talking legality, and it's like not really working, because she wants to engage me on a place I don't want to be engaged in. And so it just doesn't work. But it's like, it's just easier to answer the legal questions rather than the moral questions, because, well, that's what I do. I like the law. Law kicks ass. If you disagree, you're wrong.
Yeah. And someone in the chat, someone's right. Yeah. They said, wow, morals, to each their own. Yes, that actually is kind of the point, that you guys are allowed to do whatever you want to do. You can do whatever you do. This is legal analysis. This is not morality analysis. If you want that, there's another place to find it. Legal analysis of actual opinions. And Kurt's probably the best at doing that and taking himself out of any emotional feeling about a case.
Right. Right, because my current thought on the whole thing, like just to like show you that at least for my mind, like how it is more of a legal position. It's like, well, my current legal understanding is that assuming that Roe versus Wade gets overturned, like what's next? It's like, well, it seems like the states can kind of have almost infinite latitude. It seems like they can allow abortion for pretty much any reason. So they can allow abortion up to the last possible moment for any reason, and they can disallow abortion probably for any reason other than self-defense, basically, other than a threat to the mother's life. And then you're just into self-defense theory. So I'm like, well, states can basically ban abortion or allow all the abortion. So how's that for a moral position? As opposed to, it's like, it's just like it's a legal posture, right?
I mean, the one thing the sentence I liked that I wish we actually could remind people of most is we are now returning this decision to the body politic.
Mm-hmm.
Like, this is now your call. You guys get to make the judgment call, not us. We're not gods. We don't sit up here in this ivory tower. The body politic can speak. You guys can speak, and you guys can govern yourselves. That's why you're there.
And there certainly are moral philosophers. There are people who devote themselves to moral understanding, both from religious and non-religious perspectives, incidentally. So if you're interested in moral discussions, there's plenty of people who focus their interest on that area. I'm just not one of them. So my area of expertise, it's like my moral. I'm not in really a great position, any particular position to offer a moral analysis. I'm in a great position to offer a legal analysis. I can do that.
Yeah. And to the chat, looking for someone with moral analysis, looks like Law Talk with Mike is in the chat. He says, I can provide all the moral judgment you need. I would caution you against that, maybe just a little bit, but consider
he may be sarcastic. Who knows?
I think there's probably a hint of the sarcasm in there.
The only moral position I have is that you should subscribe to my channel, and also that of my guest, Law and Lumber. You should subscribe to us both, and if not, you're morally wrong.
And you rest on no legal foundation.
I'm not really sure I can make a legal argument for it, but I can make a moral argument that you're going to hell if you don't subscribe to both myself and Law and Lumber.
Oh God. Yeah. Okay. All right. Okay. Ooh, oh yeah. Maybe no, you're not going to hell if you don't subscribe to me, but please do. All right. Hit some super chats.
It's the ninth layer of hell.
Oh yeah.
The frozen part of hell with the Judas and the people that don't subscribe.
Oh yeah. The mutineers. Isn't that a Jack Sparrow quote? Something like that. The deep darkest circle of hell is reserved for mutineers, or something like that.
I think the darkest circle, as memory serves, I think there are only. Is this Dante where there's only 3 people in the innermost circle of hell? I'm trying to remember who they are.
Is 3 people. Judas. Who else is down there? I know that Judas is down there.
Was it Brutus for stabbing Julius Caesar?
Yep, I think it was. Yeah, I'm gonna look this up because Dante's Inferno is awesome.
Yeah, it's kick ass. It might have been Edward Scissorhands. Who knows? Yeah, okay. Long Lumber says, "Did you order your tickets to the SawCon yet?" I did. I love it. Man, it's my favorite place in the world to be. Amanda G said, became a member. Thank you for hitting that beautiful join button. Alex Sloan, is there a con coming up that covers both law and lumber? I've got wood and I'm interested. I understand the feeling. Andrea says, it's after 1 a.m. here in South Africa. Literally stayed awake so I can pay Kurt for the SawCon joke. Respect. Nabia gave 50 Australian dollars. Thank you. The Law and Lumber Lumberjacks have infiltrated the stream. Lol. Hit that sub. And let's get Kurt to 100K. Thank you for breaking this down from Oz. Excellent. I want to visit Oz. Kick ass. Chili Town says, SawCon. Great intro, and now we need to wait to end up what they're doing. This is what we're doing. Megan says, thoughts on therapy records AHR lawyers exclusively gained at NBC, as that they should have been allowed despite being self-serving, self-reporting. I hope they will make them all. Well, I mean, it doesn't really matter because they need to make them available to the public so the public can see. So I hope that they publish every last one of those pages of those confidential medical records in a PDF for us all to read so we can all read the innermost thoughts of Amber Heard. That will be really entertaining for us all, I'm sure.
Is this about tomorrow's interview? Because that's going to be a shit show.
I'm looking forward to it with the pain. Brentwood says, thanks to both of you for teaching us so much. Get this guy to 100K. Absolutely. Thank you very, very much for your support. Ben said, I'm curious how the Waldman statements even got past post-trial. Amber Heard has so many more claims that got dismissed. Guess who was best of the bad bunch? I don't 100% know. I mean, these are questions of law, and the judge could just be wrong. That's what courts of appeal are for.
Ooh, I found the answer to the ninth circle. You want to know?
Oh, yes.
Okay. So the ninth circle is divided into 4 rounds of that ninth circle.
Okay.
The first round is Cana, named after Cain in the Bible who murdered his brother. It's reserved for traitors to the family. So that's round number 1. The second, Antenora, is from Antenora of Troy, who betrayed the Greeks. Interesting. Political/national traitors. This third is Ptolemaea, for Ptolemy, son of Abibus, who's known for inviting Simon Maccabeus. Oh gosh, I wish I had the way to read this. Sons to dinner, then murdering them. So this one is for hosts who betray their guests. They're punished more harshly because of the belief that having guests means entering into a voluntary relationship, and betraying that relationship willingly is more despicable than betraying a relationship that you are born into.
So this is Lot's theory of morals.
Yeah, pretty much. Like
wow.
the property. Yeah.
You know exactly what I'm talking about, right?
Oh yeah.
Okay, just wanted to double check. Okay, carry on.
Yep. The fourth round is Judaca. After Judas, who betrayed Christ. So that round is reserved for traitors to their lords/benefactors/masters. So interesting. As in the previous circle, all of these 4 subdivisions have their own demons and punishments. Man, Dante, when he was thinking this up, good gosh, how did he do that?
Drugs.
Drugs. So many drugs.
I've never actually read it. I need to read it. That'd be good. Have you ever actually read Dante's Inferno?
Yep. Not in the original Italian. I read the translated version. Apparently, I need to actually, you're supposed to sit down and read the Italian, then like read the translated side by side, because it's really beautiful to read the Italian.
Even if you don't speak Italian?
Even if you don't, because you can get some of the pronunciation.
Not me. Have you heard me trying to pronounce English names on the channel? Rob, thanks for your voice of sanity on Joe's stream last night. What did you tell Joe?
Oh no. So Joe started a debate. Joe always starts debates. I love Joe's debates. They're fantastic. But Joe starts a debate about defense lawyers and how as a defense lawyer, how can you defend somebody? The argument of it's better for one innocent or for 100 guilty people to go free than for one innocent person to be punished unjustly. Right. And Joe was very adamantly opposed to that position. And everyone, because you had Branca, you had Sean, potentially criminal, and you had me on there. And I was like, I don't have a dog in this fight. Sean, criminal defense, Branca, criminal defense. Joe is like, how would I say? He's very pro justice and anti-crime, right? So they're just hammering at each other. And at some point in time, Joe was trying to talk. Branca was cutting him off. And I just told everyone to shut up, let Joe finish, and just kind of started playing moderator from there. The chat was mad at me. They said, why are you taking over Joe's channel? I was like, I'm not. I want to hear what he has to say. But yeah, that was the story.
So Joe doesn't believe we should protect the innocent?
I'm not putting those words in Joe's mouth. It was a good debate. It was a good discussion, honestly.
Alicia says a 20-minute preview is up on the Peacock. Noted. RJ says this woman is at it again on Peacock interview.
Oh God.
This means I would have to sign up for Peacock. I'm not doing this. There's only so far I'm willing to go. Andrew says he was not protected though, so it's absolutely false. I'm not sure what the reference is here. He was not protected though, so it's absolutely false.
Waldman?
I'm confused. Zingwei Wang gave a super sticker for $5. Thank you. Laura became a YouTube member. Thank you for hitting that beautiful join button. JC Adult says the civil rights lawyer has some interesting 1983 cases. Check him out. Maybe invite him on. That sounds like a good thing to do. I've covered actually a higher proportion of 1983 cases than I thought I would have at the start of this channel. So I'm unintentionally becoming a bit of a 1983 expert, apparently. So that would be fun. Matt Pelzer says, you and Rob are my favorite collab on YouTube. Your chemistry is great. Woot. Jennifer R. Us says, thank you for all you do. You are welcome. Vivek says, with regards to vicarious liability and being reckless, if the Sun can rely on info from Amber Heard, Waldman should be able to rely on info provided to him by several witnesses with no malice.
Sounds like a good argument to me.
Yeah. Llama's on my sofa becomes a new YouTube member. Thank you for hitting that beautiful join button. Rich Codes Web says, hey, Kurt, please check my Discord DMs regarding GoCube. I will do that. Thank you very much. Mickey says, drop it like it's hot. Law nerds. Vintage Willow says, you're going to drive Rob to drink. Yeah. Avion Fanatic says, you guys really work well together. I'd definitely be following on the Supreme Court cases. Those are fascinating. You guys provide great analysis. Thanks to you both. Is this the beginning of a great duo?
I think on Supreme Court cases, I love the Supreme Court. Your 10-minute, the speed round 10-minute thing, my favorite bit you've ever done. Honestly, when you do I'm going to race and get my analysis done before the next opinion drops. And you're like, you read the first sentence. It's like, I know where this is going. And I'm like, oh, this is going to be so good. I listen to that. I laugh the entire time. I freaking love it. Great.
Awesome. I'm glad you like it. I have fun with it. I usually hit my deadline.
You do. And sometimes the opinion, except for that one crazy fractured decision, which honestly, that's a whole like semester of law school packed into one decision. It
took me a while to understand it.
Yeah.
Okay. Kate says, sorry if you're already giving them, Rob, but your thoughts on maybe juror talking mainstream media? Love the Dante chat, by the way.
Thank you on the Dante chat. I saw some of that. I know that Joe's going to cover the interview that he apparently is given. Minnie Allen, I love this. Uncivil Law and Lumber, fantastic. But on the juror, I'm reserving judgment on it. One, I don't know what they use to authenticate him as a juror, so I'm not going to make a judgment call on whether I think he's real or not. I'm just going to say they took some method to authenticate him. Two, as long as they are not eliciting comments about whether he did or did not see social media or suggesting that he violated the court's order on what they were supposed to do, I'm fine with him talking. I wish that maybe we'd hold off for a little bit before he goes into a tell-all until we at least get order signed. That'd be nice, but I can't control it. So we'll see what he says.
Let's see. Remen says 2021. Do you find that most lawyers are conservative? I'm a hedge fund accountant, and I find that most of my colleagues and I are right wing. It depends on the aspect of law. I think that law school, at least, well, when I went to law school, is probably more evenly divided than most graduate programs. Well, I don't know if that's fair because some are probably pretty right wing. I'd say it's fairly even. I'd say the Federalist Society has done a really good work in terms of the conservative right wing thing, which ironically was vetted by Scalia at Yale, which is kind of which in retrospect is kind of hilarious because now apparently the Federalist Society is a major evil far right group of some kind. But yeah, I don't know. I think the patent law tends to be a little bit more conservative because they're all engineers, and so
domestic litigators are a lot more liberal. I'm not. You guys will never guess my politics. I'm telling you right now. But I'll say that a lot of domestic relations litigators and a lot of civil litigators that I've seen tend to be a little bit more left. But there's a fair number of people, and lawyers are pretty good about understanding both sides. Generally, sometimes. Mm-hmm.
I've heard you had I've heard you. Wow, this is such a bad joke. I don't think I want to tell that joke. It's unfair. I'm going to reserve that one.
Save it for the next super chat, I guess. Oh God, don't hit me with it when I'm on stream. I almost died.
Yeah, Crazy Cat Queen says brilliant. So marriage and polygamy, discrimination against religion? No, not necessarily, because you don't need to necessarily be religious for that. See, the thing is, it's not necessarily a but for. People there are religions who believe in polygamy, but it's not inherently religious. You couldn't say that a person who is polygamous is necessarily religious or a particular religion. So it's not inherently discrimination on the basis of religion. Where if you're discriminating on the basis of someone being gay, it's inherently because they're one sex versus the other. It's an unavoidable reality. So that's the difference, right? It's something that is a necessary implied condition versus merely an association. So it's not quite the same. Muslim, Mormon, if other polygamous, but it's against the law. See, no, you can do this because you're not discriminating on the basis of religion. The fact they're religious or not is irrelevant. You don't know if they're religious or not. So laws against polygamy is discriminating against non-Judeo-Christian religions. No, the logic doesn't flow. It is not a logically required relationship. Jen becomes a new member. Hen House Bath Company, Woot. Kurt, thanks for your coverage of January 6 hearings. I don't know if I'm going to do any more, and if I do, I might just do them on locals. Also love getting both of your legal insights on JD versus AH. Legal insights on AH. I did a DNA test, and she's 100% that bitch.
Jesus Christ. It just took a DNA test. Turns out she's 100% that bitch. Who doesn't shut your fucking mouth? Kurt melting down right now is life. Kurt melting down right now just made the stream.
you gotta love the jokes to roll with me, man. You gotta roll the jokes.
Oh God. Okay, that was great.
AKBX says the innermost circle is the devil with 3 heads. Over each dangles the legs of 3 people that he feeds are Brutus, Cassius, and Judas. Hangs over the mid-face for the most punishment.
Oh my.
Stephen Glasker says, wish I was on the show. Your trans discrimination argument is flawed because of a huge fallacy that men and women can switch genders. It isn't me arguing that. It's just it's a logically tenable position. It's scientifically logical. Therefore, private business can discriminate. Okay, let me show you. Let me see if I can argue this in a way that shows you why you're wrong. Okay. All right, I can even do it without switching sexes. I can do it this way too. All right, I can do it in the funeral case. You have a male dress code and you have a woman's dress code in the funeral place. A man comes dressed according to the women's dress code. You say he's not following the men's dress code. The only reason that you're discriminating against him is because he's not a woman. He would be if he were a woman. See, like you don't have to agree that people can change gender. I can do it without that. It's like, okay, he is dressing as a woman would dress. You say he's not dressing as a man would dress. So you're saying if he dressed as a man would dress, he'd be okay. But he's dressing as a woman who dress. So therefore you're discriminating on the basis of sex. So even if like you say he can't, so you don't have to even like create the presumption. You can still do it without it and still logically flows. Does that make sense, Ron?
Yeah, you have to make that first identification.
Yeah.
Like the second you make the first identification.
Yeah.
And then you go from there.
A person comes in wearing female dress. Are you discriminating against them or not? If the reason is because they're a male and you wouldn't, if the reason is because they're a male versus because they're a woman, that is your basis for discrimination. Now you're discriminating on the basis of sex. It's unavoidable. It's a logically required prerequisite. So yeah. So fair enough. Jennifer became a new YouTube member. Thank you for hearing that join pun. Vega versus Tekoa could be interesting. However, most would be shocked at how many talk to the police after being advised of Miranda. It still surprises me. You know, that's an interesting point, Tiger Cop, because when Miranda itself was being decided in the long, long ago in the far, far away, you can read people making exactly this point. I think they were made in the oral arguments, and I think might have actually been in the Miranda decision itself, and maybe the dissents thereof. But people were definitely making this point when Miranda was being decided. Oh, if we give people their rights, people just invoke their rights all the time, and the police will never solve any crimes ever. Fast forward 50 years later, with the Miranda warning being in every police procedural TV show and movie ever, it being soaked into the consciousness that you probably can recite it without too much prompting, and people still, I think it's 85% of the time, waive their rights. So It didn't really pan out.
Yep. And you know what tomorrow is, Kurt? It's Shut the Fuck Up Friday.
It is Shut the Fuck Up Friday. We need to have the Pop Brothers at law on because they sound like fun people.
Yep.
We need to ask them where the best stuff is and if I can roll with them deep. And I say I've never smoked marijuana, which actually technically is true. And what they think of that could be fun. Lexi says hashtag uncivil lumber. Excellent. Crazy Cat Queen, $2. Oh man, you skipped my question. Did I?
Nope.
I don't think so. I remember reading it.
She belays that order in a future chat.
Angie says, I couldn't have made it through C-SPAN 6 coverage day without you. It was fire. Hype. Jen became a new member. Thank you for hitting that join button. Lindsay says, first Mike telling me my favorite band sucks, and now I hop on to hear Rob very quietly singing Lizzo to Kurt. My timing is on point today.
I would say so. Did you hear that? Mike wants a shirt that basically says your favorite band sucks.
Yeah.
Oh, God.
I like it. Crazy Cat Queen says, belay my previous chat. You came back to it. Yeah, the chats are answered in order that they were received because nothing else seems fair. And Jocko Splinick says, you too see HG Tudor's video, why Amber Heard is a narcissist. I don't have to. She's a narcissist. I'm yeah, that's pretty on point.
Mm-hmm.
So I believe, well, no, there might be one more. Let's see. Okay, Yep became a new member. Yep. Doing little Muppets there. So, the 3,500 of you who are still with us, I appreciate it. What else should we talk about, Rob? Or should we just end the stream?
I don't know. Let's you know what? Let's wrap it up because we have Supreme Court opinions coming out not next Tuesday, right?
Yeah, Monday is a federal holiday. It is Juneteenth.
Yep.
So even though it's the 20th, but we celebrate on Monday. So
yep. Opinions come out Tuesday. So let's do that.
Okay. We could do something on Tuesday. You want to come on and do a live speed round?
Oh, yeah. Let's do that. What time? They dropping at 10?
10 o'clock Eastern.
Let me double check calendar, see if I don't have any hearings. That'd be funny. That'd be funny. Like Judge, I know I have a hearing, but I really want to be on this live stream where I break down Supreme Court oral argument or
you never know the law
10 minutes.
You never know, Judge. The law might change while we were having this conversation. You need to know these things.
I am free Tuesday 10 a.m. Let's do the breakdown.
All right. Well, thank you for all the people who have subscribed to the channel so far. It is really, really appreciated. We are now 2,900 away from hitting that mark. I would really like to hit it by July 2nd if I can. It's a little bit ambitious at this point, but I'm hopeful because it's my last day of work and I want to make it feel like I've accomplished something. So yeah. So I will let my guest go. My guest has been Law and Lumber. Remember, check him out on his channel. I will remember to tag him, hopefully. I have been Uncivil Law. Remember to do all the YouTube things, like, comment, subscribe. Until there, my friends, I hope all is well. Cheers and goodbye.